right. Sorry about that, folks. My name's Matt Lutz. I founded Atticus Family Law. Been doing this 22 years, and we're going to talk about real estate today. All right. Let's see. Amongst our questions, none here, but we've got some over in this other place. All right. Let's see here. We got James. How do we choose the value for our property? All right. So in a divorce, on the property side of things, we got property and debt. Debt's just basically anti-property, right? It's all a matter of positive or negative equity. We've got to figure out and decide as to what everything is worth. And of course, when things like real estate have varying values. Last year might have been down, this year it might be up, next year might be down again. Over the course of your ownership during the marriage, your real estate may have changed in value. Almost assuredly has, right? So then when it comes time for divorce, we need to determine the value. And there's a few things that come into play here. But the first way I'm going to answer this question is there needs to be a date valuation so that we could say, all right, for this particular point in time, this is what the house was worth. And then there's no question as to what that is. So we dig into, normally what happens is divorce papers are served, then they're filed, and a court schedules an initial hearing. Judge is not making any decisions at this hearing. It's really low key, except that across the Twin Cities metro area, pretty much all the 7 counties use a practice where the presumption is that the date of that initial hearing is going to be the date of your valuation. And so when it comes to something like the house, if there's a circumstance where it's so contentious that we need to hire an appraiser, come out, spend $300, $400, $800 on appraising a property, depending on its size, if you got outbuildings, if you got horses, what's the property worth? That's the date we would use. Sometimes we can also coordinate that with like real estate agents that might just do a comparative market analysis and give us a number to work with. And also as it relates to, you've got the total value, but you also might have a mortgage. And so that would be the date that we would look to find out how much was owed on the property so we could figure out the net value of that date evaluation. And of course, the same is going to go for our other assets, retirement accounts, bank accounts, Kelly Blue Books on the cars, other assets that you have, let alone debts and credit card statements, so on. Now, I got to warn you here. It is presumptive that initial hearing, which is called an initial case management conference, is the date of valuation that you'll end up using. But it's not written in stone. It's not absolute. Now, as a divorce goes on, like one of the reasons why we use a date evaluation is we can't, collect all of our own documents at the beginning of the divorce, showing all these values of bank accounts, retirement accounts, our own Kelly Blue Book, the value of the house, any ESOPs, RSUs, stock options, any of this sort of stuff relative to this is the value. And then we're trying to sort out mediation. Maybe the initial financial discussions fall apart. Then we go to maybe we're sorting out children and parenting time issues, dealing with whatever there. We come back to the financials, and then someone says, well, I want updated financials. Now we got to go back and get updated retirement statements, bank statements, Kelly Blue Book, all the stock options and equity assets, let alone updated appraisal on the house. And then someone doesn't like that. And then we get to the pretrial, and then we want to update it again. And we're always chasing new values. That is a horrible waste of time and attention, a giant waste of money. But also, more importantly, it probably would result in a whole lot more trials because people would resent that so-and-so wouldn't agree to financial settlement back when the house was worth what they wanted it to be worth, and now it's worth something very differently. And so they're still trying to cajole the other person to agree to that initial house value. And then maybe the retirement went the opposite direction. So the other person's really desiring to use a much later valuation date. You can see why, if it just makes more contention if we also have to bring in competing dates. But there is some good reason for this. I've had a number of divorces where the parties have been separated for a number of years. I had one divorce where they'd been separated for 4 years. And the real kicker is, upon separation, these two, like, you don't know why they just didn't get divorced at this point. They got along so well that she moved out. They went to the bank. They refinanced the mortgage into his name solely, so she didn't have to worry about that, and took out the additional equity and gave it to her. Granted, she was carrying a bunch of credit card debt, and so she basically used it to extinguish that, and that would have been marital credit card debt. But there was that issue, and then when we got to the divorce 4 years later, we wanted to use a date evaluation from 4 years ago, basically the equivalent of 2021. And the other side said, no, we got to use present value. I'm like, we already had, like, addressed this, and we don't want to, like, he's been the one solely paying on this mortgage for 4 years. He's paid down the mortgage considerably without any contribution by her. He's developed so much more equity, let alone maintain the property and been more responsible for its appreciation. And that case did go to trial. But that's a kind of an example of why there would be a good reason to want to use a different date evaluation. Some really compelling reasons. But that's essentially the way we end up using a date evaluation. All right, let's see here. Other questions we've got. Michael, what goes into home appraisals? I can tell you that generally, the best information as to what a house is worth is what it sells for. But we can't be in a position where we are always just selling the marital home. You know, we've got children who've become accustomed to one of those houses. Maybe it's in their immense best interest to stay in that house. We don't want to have to sell it if we don't want to, and let alone just all the added expenses that come with selling a home and moving two people out versus one. It's very expensive and costly on marital estate. And so the general preference is, if one party wants to keep the house, great. Then we're going to allow them to keep it. We don't have to force the sale, but then we still have to figure out what it's worth. Now, in an appraisal, the real guts of an appraisal is as follows. They're going to find out exactly what you've got. It might be 1,200 square feet, 3 bedroom, 1 bath. It might be 3,000 square feet, 5 bedrooms, 5 baths. And, you know, like, whatever it is, we want to figure out exactly what the house is in regards to all the key characteristics. The age, does it have a 3-bay garage? Does it have a 2-bay garage? You know, all these sort of things. And they inventory that with all their data and records, plus additional site inspection. And then they're going to find other houses very as similar as possible, as close geographically as possible, that have sold in the last 6 months. And they use 6 months ideally. And if we could say, look, I mean, you just imagine it as being like, if you're in a Woodbury townhome, right? And we got a question as to what that's worth. There very well could be a bunch of 2-bedroom, 2-bath Woodbury townhomes of the same age, same size, same qualities, same number of garages, all this sort of thing. And there could be easily 5 of them that sold recently in the last 6 months, and they're all within like a mile, because there's parts of Woodbury that are just all townhomes that are all very similar. At which point then, if all, say, 5 or 6 of those sold between $250 and $275, we're going to just average it. And if it rounds out and says average value of all of them is $260, that's going to settle it. Like, if you had a compelling appraisal like that, that's not likely to be a trial issue as to disputed value over that townhouse, because it's just so compelling. The tricky part is when you get into, oh, great, I got this 40-acre Cochrane horse farm with these outbuildings and various stables, let alone it was a custom build and there's not really many like this. And the appraiser has to find a bunch of other properties, maybe go beyond 6 months and go to 12 months, that are possibly in the area, at which point then it's probably a much greater spread than 1 mile. And then they're going to end up having to make adjustments because maybe this farmhouse, this nice ranch is 4-bedroom, 4-bath, but every comparable is only 4-bedroom, 3-bath. And so then they're going to have to make an adjustment saying, all right, we're going to reduce or we're going to add value to these others as if they all had 4 baths, because that's what they do. Same thing with the garage stalls and the square footage and the age and a bunch of other stuff, is they make these price value adjustments so that then when they do the average, it's almost like they're averaging apples to apples. And then they can compare it back to the original apple, this horse farm. That's where it gets tricky and more contentious. And then you end up having to dispute over appraisal values. All right. John. Let's see here. No. All right. This is a good question. No, we don't do the equalization. Well, first off, when it comes to marital division, the statute says we want to divide equity equitably. Equitably. Which most of the time, well more than 50% of the time, is equal division. Sometimes there's good reason not to do an equal, but it's still in the ballpark, 55-45, that sort of thing. And other times you get into circumstances where it's like, well, instead of paying spousal maintenance, we're going to give extra equity. So it ends up being like a 70-30 split. But the would-be maintenance payer who's only getting 30% is glad to give up all that extra equity relative to the maintenance claim, because that sort of thing was brokered as opposed to court-ordered as unequal. But we're bringing in more than just property division when those unequal divisions come about. But no, we don't have to worry about every individual equalization. So it's not as if like we know that someone's got a Cadillac Escalade and it's got $40,000 of equity in it, and so we need a check for $20,000 so that they each get $20,000 of equity there. And then meanwhile, he's driving this wonderful Mercedes, and it has $50,000 of equity, so he's going to write a separate check for $25,000 back to her. And then, like, ultimately, it's almost like a check for every asset. No, we don't do it that way. We put it all together on a marital balance sheet, and we figure out and say, all right, look, out of all the assets, be it the house, the retirement accounts in his or her name, say, all right, she's getting the house, the retirement accounts in her name, her vehicle, these recreational things, other certain assets or investments, and then she's got certain debts in her name, and the total net is $2.5 million. And then meanwhile, for him, he's getting the cabin and his retirement, blah, 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 and his is $3 million. At which point then we say, all right, to equalize it, it's $250,000 from him to her. And then they both have $2.75 million. And so then where's that going to come from? Can we do a transfer of $250,000 from one of his retirement accounts over to hers? Or there's that much additional equity in the cabin that he's just going to choose to refinance, and so on. And then we basically have one equalizer. Now, there is a caveat there. And this is where my example is not great. A lot of times, or first off, if you sell your car outright and say you get that $40,000 of equity, you're not going to pay taxes on that because you you bought it with sort of income, and that income was already taxed. And so we know that generally there's not like an income component unless you're like a particular collector, blah, blah, blah. A lot of things are purchased with what we call post-tax dollars. Your money in the bank is generally post-tax. Your other assets that you have, your household furnishings, sometimes even like the equity that you develop in whole life insurance policies, this is all post-tax. But even like your Roth IRA, which you've already paid the taxes on that income, now you're investing it, and yes, it's growing, but you don't have to worry about taxes on that. That's great, and we can equalize that pool of equity amongst all the post-tax assets. But then there's other things such as your IRA, your 401k, certain other investments. If you make a lot of money on selling a marital home beyond the exemption amount, because like a married couple, if they were to sell their marital home, their primary residence, the one that they homesteaded, and they were to make more than $500,000 of equity on the sale of that house, they're only going to be able to, yeah, they can shelter $500,000 of profit from any taxation, but above that, we're going to have to deal with it. So a lot of times when we're doing marital balance sheets, generally the house is going to be post-tax because most people don't sell for with that much windfall. And so then there's a lot of the retirement, the IRA, the 401k, some other certain investments that are going to be equalized separately. Because if you try to cash out your 401k right now, not only are you probably going to encounter early withdrawal penalties if you're less than 59 and a half, but you're also going to have income taxes that's due on all those withdrawals because you haven't been taxed on any of that money yet. So we want to treat that separately because, as I say, a $300,000 house is not worth $300,000 in your 401k because the 401k hasn't been taxed yet. So if those are the only two things, there's no mortgage, nothing else. One spouse taking one spouse taking the other is not equal. So we're going to oftentimes have two equalizers in that circumstance, James. All right. Or John, sorry. David, what question do you have here? Disposition of a house. His question is, how do we dispose of the house in a divorce? So there are four options in a divorce as to what happens to the house. One, first two is just spouse A, spouse B can keep the house. Generally, we're going to award it to one of them and not allow them to continue to jointly own it. So it can go to one or the other. Third option is to sell it. And there could be an agreement to sell it. Sometimes the facts and the underlying circumstance is so problematic that even if there's not a dispute as to who should get the house, the court still orders it sold after a contested trial. Sometimes if both parties want the house, if there's not a really good reason why one party should get the house, then the court's going to order it sold. And then the fourth option would be if you're so far underwater and you can't make the numbers work, you're going to do a strategic foreclosure and walk away from it. But those are the four options. So generally the preference is to keep the house in for one of the two. But otherwise, those are the four. Let's see. Daniela. Let's see what you're talking about. Buyouts. Yeah. Okay. So there are four elements of every piece of real estate that we end up talking about. First off, there's the title. It's just whose name's on it. And generally, when we get done with the divorce, we're going to want only one person's name on it. Secondly, then there's the encumbrance. being the mortgage, second mortgage, HELOC, who's obligated to be paying to be responsible? And is it the existing encumbrance that the other person still may be named on, or are we talking about refinancing and having a new encumbrance that the future recipient spouse, or now ex-spouse, is going to be keeping or is going to be taking solely in their own name? Then there's the question of the equity in the real estate, and what's going to happen with the equity. Is the person that's getting the house going to be able to keep all the equity, or is some of that equity need to go over to the other person, thereby increasing the amount of the mortgage that needs to be refinanced? And the fourth component is occupancy, which is who's got the right to be there. And if the parties are still cohabitating, is there a deadline by which the other party is required to get out? So with those four elements, we end up with a question of this buyout question. So a lot of times it's very typical in especially middle-class divorces where there needs to be some of the equity that needs to move from the house to the spouse that's not retaining the house. There's just not enough other pools, and maybe it doesn't make sense to, I don't want to say unfairly, but yeah, we'll just say unfairly, like saddle somebody with having to take all the retirement that's tied up in retirement accounts and subject to taxation and a bunch of other stuff, and then be left cash poor because they didn't get any money from the house. Meanwhile, the other party gets the house, but all their money's in the equity of the house and they don't have any retirement. And that can be difficult. And sometimes it's a whole lot easier to say, all right, let's make sure that we're going to split the retirement a little bit more fairly between the two of you. But then the house recipient is going to be obliged, usually somewhere between 90 and 180 days, to refinance the house and deliver a certain dollar amount to the other spouse within that timeline for the equity, that their share of the equity that's in the house. And so then thereafter, that also accomplishes consolidating the encumbrances, the mortgages, the HELOC, whatever it is, into the name of that future housekeeping spouse solely, so that then the other spouse doesn't have their credit tied up. So that's typically how we do the equity buyout on a house. All right, let's see here. Matthew's got a question about taxes on home sales, but I already covered that. So I'm not going to go over it again. Working with a realtor. Okay. Yeah, because sometimes in a divorce, you're going to end up with people that are very, it's not easy to get along with your soon-to-be ex-spouse in some divorces. And with that, then, how do you go about listing a house for sale cooperatively with a real estate agent? In Minnesota, you're both going to be required to hire a listing agent mutually. So you got to mutually agree as to who's the real estate agent's going to be. And then that real estate agent's going to expect some level of cooperation in regards to, one, what repairs or other work is going to be done on the house before it's going to be listed, how's the house going to be staged, and the condition it's going to be kept during listing, what the list price is going to be, when there should be adjustments to the list price, or at least, well, maybe you can't predict that, the real estate agent's going to have some recommendations as the longer it stays on the market. And then as you get offers, dealing with those offers, whether it's acceptance, counter proposal, just outright denial, and then once there's an acceptance, doing any of the stuff that's necessary for the sake of complying with that, cooperating with evaluations, or not evaluations, like a home inspection, plus the bank is going to want to do an appraisal of their own for the buyers to verify that the home is worth what the purchase agreement says. these are things that you'll talk to a real estate agent about, but nonetheless, these are things that are on my radar as a divorce attorney for the sake that I realize that parties have to cooperate to do these sort of things. Now, ideally, you got some, the parties can get along enough for that, for the sake that you both have the desire to maximize the sale value of the house. And so you've got some considerations there. Secondly, you've got some opportunity perhaps to streamline some stuff around between the attorneys to basically kind of provide some broad stroke considerations. Generally, best practice for the attorneys to encourage the parties to defer to the recommendations of the real estate agent, because that's the professional they chose to trust in this circumstance. And it's kind of hard to like second guess that, right? Like it's a little bit like questioning your doctor. But then if push comes to shove, one of the things that we can do, especially in highly contentious divorces, is either while the divorce is pending in a temporary stipulation or court order, or if the house has to be sold after the divorce, we can ask the divorce decree to include a provision that once the real estate agent is named, they get tiebreaker status. So if the parties can't agree, whatever the recommendation of the broker is, or the real estate agent, it basically is the tiebreaker. And so we got to have a real estate agent that's willing to cooperate with that and have that power. But that can be really valuable, because then all three of you know the property and the real estate agent knows the market. You're like the three best people for that. And that's nice because it's an odd number, thus making a tiebreaker opportunity. Because your only other circumstance in that is dragging it back in front of the judge. And the judge is not going to be pleased to be brought in on something like that. All right, we got a few more minutes left here. Let's see. Yep, we talked about that. Good question, Jessica. Again, enforcement. Well, we're talking about a little bit enforcement in that if in the divorce, someone's obliged to do an equity payment or to refinance to get it out of their spouse's name, or now ex-spouse, or even somebody's refusing to exit and move out. Sometimes we have to do enforcement actions right after a divorce to compel the other side to do what they should have done. In the way that we like to draft the divorce decrees, we absolutely want some explicit language in there, not only around exactly what's expected of them, because sometimes it's the ambiguity of a poorly drafted decree that requires this sort of enforcement. But then also, if we've already gotten a sense that the other side would be perhaps a jerk in this regard, have we also been able to put in the clause that specifies an explicit threat of attorney's fees, saying that if we've got to take you back, then you're allowed to ask for reimbursement of your attorney's fees for having to drag you back to court. And so that's another valuable opportunity in regards to enforcement. Fortunately, in enforcement actions, there's not the explicit obligation to have to mediate before bringing a court motion for enforcement. That's good. When it comes to somebody that's refusing to move out, so let's just say the husband was awarded the house and then the wife refuses to move out. Perhaps we can get back in front of the family law judge to make that happen. Or otherwise, also sometimes we can consider an eviction action, which then is a thing that we've done in the past. It's not pretty and it takes longer than you ever want it to take. But if you're not going to have any love from the family court judge on addressing that, although you should, but some of the power of the family law judge isn't nearly as compelling as just the swift, like some ways, sometimes eviction is more swift. And so we can do that as well. But there's some other ways to head that off with really good drafting of the divorce decree, which is essentially what we try to do. So like we want to avoid any headaches. Basically there's a bunch of arguments, a bunch of headaches, a bunch of lost sleep that we don't want our clients to suffer in the years after the divorce. And that's why we put in the work we do on the drafting. All right, we're coming up on 30 minutes. Thanks for your time.